A school district is facing a lawsuit over alleged free speech violations. Not the only school district that this kind of issue has happened in, incidentally. School districts have people come to their hearings and say stuff. Sometimes the school board doesn't want to hear the things and tries to expel or silence the speakers, and that usually results in a lawsuit. So this story is in no sense unique, but I thought, might as well cover one of them. So this is a lawsuit relating to this issue, which is not unique in any way, but we'll cover the one. Two people were removed from a school board meeting in El Paso County for holding up signs for several board members to resign, and they're now suing the school district, alleging the district violated their rights to freedom of speech. The school board, of course, is a governmental entity. And so people holding up signs saying resign is expressing political speech. So there are issues. The lawsuit filed in federal court accuses the school district of treating community members inconsistently based on viewpoint. We like the signs that support the school districts. We dislike the signs that don't support the school district. Viewpoint discrimination is a real problem. It is at least strict scrutiny. And depending on how you read the case law, it might even be worse than that. It might be per se unconstitutional, which would allow for the government to never do it, ever. So it's at least strict scrutiny if you have viewpoint discrimination. In the complaint, the plaintiffs allege that other community members at previous meetings faced no such punishment for comparable actions. The complaint also names the school board president as a defendant, along with security personnel who assisted in upholding unconstitutional policies, practices, and customs. The case was brought to vindicate First Amendment rights. At the school board meeting, the people suing each held up signs at chest level reading, "Rick, Lori, John resign," referring to members Rick Van Wieren, Lori Thompson, and Graham. Graham told the two their actions were out of order and violated rules of decorum, telling them to be asked to leave if they didn't put the signs down. They then halted the meeting in order for security to intervene when the two continued to hold the signs, despite the warning, being escorted out of the building. Of course, they are a district taxpayer and grandparent of two children and is an Ohio resident. But, it doesn't really matter because it's open to the public anyway. And it doesn't matter if you have children in the school district or not. It's a governmental function. The public, who might have thoughts. Those thoughts might include you're doing a bad job, resign. So, First Amendment issues because of all that stuff. So maybe there were other people holding signs on other occasions. So the issue isn't the holding the signs, which would at least be subject matter or viewpoint matter neutral, or it might be just a means thing. We might be in intermediate scrutiny at that point, right? You can say what you want, you just can't hold up signs, maybe. Maybe that's the rule, right? So you might even be in intermediate scrutiny at that point. But when you allow some people to do it and not other people, you have an equal protection problem. In the recording of the school board meeting, Graham was shown asking members of the sign to put down distracting signs. If they had not put them down, they'd been asked to leave. The difference was they put down the signs. People don't have the right to come into the meeting disruptive. It depends, I suppose, how they're going about it. Plaintiffs say they've suffered injury in core political speech of their constitutional rights, seeking award of damages and costs, also preventing the district from prohibiting signs as long as they don't interfere with the ability of people to watch and change the meeting. Say they want the district to change the method of prioritizing certain groups during public comment to make it more equitable. Current policy prioritizes students, staff, and parents, followed by active members of the committee, then district residents and taxpayers, and finally all other citizens. Priority is also given to speakers who have not addressed the board within the last month. Is that a good way about the government doing things? Should those people have priority? Debatable, because maybe it doesn't matter. Maybe everyone should just have equal priority and, first come, first serve or something. But maybe that's okay, maybe not. But if you're specifically not allowing people to speak because of the messages they're speaking, you've got a problem there. So not the only lawsuit like this by any means. This kind of thing is happening in many other places around the country. And I just brought this particular case to your attention just to highlight the overall issue. So that is what's going on there.